Good morning, everybody. Happy Tuesday. Thank you for joining us today. This is number 9 in the series of webinars we're doing on the secrets of a successful retirement. Today's topic is Probate 101, the do's and don'ts, and we have a special guest speaker, Andrew Friedman. My name is Tara Kendrick, and I'm here with Bill Witt, and we are part of Senior Resource Center. And we're so glad you joined us, and we still have quite a few in the series left, so be sure to go on our website to check it out. Also, during this webinar, you can go up to the top. There is a bubble. It's a blue bubble. Click on that, and you can type in questions that we'll be answering at the end of the presentation. So with further ado, I'll have Bill take it over.
Thanks, Tara. And welcome to everybody that's joined us. Our number of viewers keeps going up. We appreciate everybody's interest in the topics we're talking about. Most of us want a safe, secure retirement. And these are very unprecedented times. If you live in the Austin area, you know that housing prices are skyrocketing. Things are happening that we haven't seen before. And so it's important to plan your retirement. And obviously, one of those is to have your legal house in order. And we're very appreciative to have many trusted partners. And Andy Friedman is one of our special friends and trusted partners. He's helped many of our clients prepare their legal house so that their wishes are protected. What we do at Senior Resource Center is 4 things. We do comprehensive retirement planning. That's building 30-year retirement plans to make sure your money lasts as long as you do. We do tax planning, not tax preparation. And our goal there is to pay less taxes. And we've got a webinar coming up in the future that'll deal with just that specific topic. Long-term care planning is a very important part of what we do because it's one of the great risks we all face as we get older. Most of us are living longer, and the cost of these care facilities or care at home keeps going up, and the length of care keeps going up. So having a plan is important. And finally, estate planning. That's what we're going to be talking about today. Most of us will be passing assets to the next generation, and there's multiple ways to do it. And having a plan is better than not having a plan. So with that, I'd like to turn this, let me say one more thing. Tara and I are not attorneys, Andy is. So while we're going to talk about a lot of legal topics this morning, everybody's needs for legal documents are unique and specific. And so what you need to do is arrange a meeting with an attorney like Andy, who specializes in elder law, and talk to him about the legal documents, get your questions answered so that your legal house is in order. And with that, I'm going to now turn the presentation over to Andy and have him talk about Probate 101.
Thank you, Bill, or thank you, Bill and Tara. Appreciate the opportunity to come here and talk to you all this morning. We're talking today about probate. So let's dive right in. Usually this is understood, probate is, as a process for transferring title. Now, I want to be clear, what I'm talking about is a legal process that's conducted in court. And what is the probate process? Well, traditionally, it meant validating a will in court. That means when you have a will and you die, it doesn't do anything until it's given power or given effect. And that's the process to give a will effect is called probate. So when you hear the term a will is admitted to probate, it means the judge has stamped it approved. The state of Texas now puts its full power behind it, and it has legal effect. Now, that's the traditional form. It has been expanded, more or less by common sense, to include administering the estate, the probate estate, after someone dies. So it's not just saying, okay, the will is in effect and the executor named in the will is appointed, but also it includes the process for administering that estate. And we're going to discuss what that includes. However, probate itself in Texas, at least, if not in some other states, has been expanded to include the legal right and duty to care for another person or that person's property. The broad term for this is guardianship, and sometimes it's called living probate because it's held in the same court that hears wills. Now, when does probate happen? Well, it depends on whether you're talking about the lifetime guardianship or living probate, or after death, the traditional or testamentary probate. Obviously, if you have someone who is incapacitated, that person is still alive. So the guardianship that you're talking about is a lifetime process. And similarly, when someone has died, that's when the traditional probate or testamentary probate takes place. So let's start off with guardianship. Um, Guardianship is, as with all other forms of probate, it's a court overseen process, which means it's public. This isn't something that's done in a back alley or privately. It's done in public. It's transparent, and what that has taken to mean historically is it happens in court. There are two kinds of this kind of guardianship. One is a guardianship of the person, and that is more or less what people think of for guardianship, where someone is disabled or more than likely mentally incapacitated and needs someone to take care of themselves, to take care of them, then the person who is appointed to take care of the disabled or incapacitated person is called the guardian. That is the guardian of the person of the disabled person. There's a second kind of guardianship, and that is usually falls on the heels of this, and that is a guardianship of the estate. In other words, at the end of a guardianship proceeding, when the disabled person has been determined to be legally incapacitated and needs to become a ward of the state, then the judge will appoint a guardian for that person and will probably ask rhetorically, if you can't take care of yourself or you're a danger to yourself or others, you probably can't balance your checkbook either, can you? So maybe we need a guardian to take care of your property or your estate. The guardianship of the person begins with a lawsuit. And do understand, to get in front of a judge, you have to bring a lawsuit. That's just the definition of it. So you're suing the person who's incapacitated, and it's called a competency hearing. And the general rule is it's a contested hearing. In other words, it's not just done and everyone agrees on it. It's actually an argument. And the disabled or incapacitated person may not be able to make that argument. So, as a matter of course, the judge will automatically appoint an attorney called an attorney ad litem, which stands for attorney for that hearing, to represent the person who's being sued. And this is, if you think about it, also a good protection. It means that people aren't suddenly being railroaded. This isn't, send someone off to the gulag. It's a public hearing, and there is an argument in open court in public about whether or not this person should be made a ward of the state. And that, in fact, is the first goal of this kind of a hearing, to determine whether that person needs to become a ward of the state and to so judge him. And then, secondly, to appoint a guardian with a duty to care for the ward. And this kind of care is probably best understood as someone who serves as a new parent for the incapacitated person. They have the duty to take care of the incapacitated ward by determining where he or she lives, who has access to the ward, where the ward can go, and in what kind of activities the ward can engage. So it's very much like what a parent does for a minor child. And that is, in fact, legally how the word is seen as kind of a very elderly minor child. What is a guardianship of the estate? Well, this is, as I mentioned, triggered by the court or specifically the judge asking the rhetorical question, if you can't take care of yourself, you probably can't balance your checkbook, can you? Well, if the judge answers that in the affirmative and says, yes, you can't take care of your property, you can't balance your checkbook, then the judge will then go about appointing a guardian to take care of the estate of the property that the ward owns. Now, what are the concerns associated with that? Primarily, This is a lengthy process. Guardianship of the estate, once appointed, lasts until the ward either dies or regains capacity. Now, let's be honest. The capacity we're talking about here is mental. And if you lose mental capacity, again, I'm not a doctor, but my understanding is it's a one-way street. You're not going to suddenly regain your mental capacity. It may be a slow process, it may be a quick one. But bottom line is, if you need a guardian for your property as well as for yourself, that person is going to be with you for the rest of your life. Now, the law that says you have to conduct these hearings in public also governs how the guardianship of the estate is administered. That means oversight. The judge has to make sure the guardian of the estate is doing his or her job. That kind of oversight, because it's before a judge, takes place in open court. As you might imagine, there are court costs with that. The hearings will have to happen at least quarterly, if not monthly, for the rest of the ward's life. So for each such hearing, you're going to have the court costs, in other words, pay the judge and the staff at the courtroom for their work and time, and also the attorney's fees, because the guardian of the estate is what's called a fiduciary, and they owe a duty that has legal ramifications up to and including potential criminal violations. So that fiduciary has to show up in court with an attorney, and the ward's estate is used to pay for both those court costs and the attorney's fees. There's something else involved, and that is people with a vested financial interest in the ward's estate. The ward's creditors have a right to be there at the hearing. They appear through their attorneys, and the ward's estate pays for them as well. And remember, this continues until death or removal of the disability. So this can be an extremely costly process. All right, now we're going to switch over to the post-death probate or testamentary, the traditionally thought of probate. Once again, this is a legal proceeding to transfer the title from the person who's died to the people or person who should receive it. Once again, this is a public forum conducted in court. So again, it's triggered by a lawsuit. Again, this is more of a friendly lawsuit because there isn't really another side. This is requesting the court on behalf of the state of Texas as sovereign to accept the fact as public record that the decedent has died and that he or she has left a will and that the will needs to be given force and effect, which means admitted to probate, and the executor named in the will needs to be appointed. All these happen in court. So just to be clear, when you draft a will and you say, I'm giving all my property to so and so, or to charity, or family, or a mix, and I name this person to be an executor, that by itself expresses your wishes, your will. It does not appoint that executor, it does not transfer the property. It directs the court and the named executor that the judge should appoint the executor to serve and that the executor should follow the terms of the will. Um, it is worthwhile noting that this will only covers what are called probate assets. That may seem circular. It's a probate proceeding, so of course it only governs probate. But probate assets are those assets that have a title, that the title is in the name of the deceased person or in the name of the deceased along with other people. All right, now the probate process that we're talking about now is primarily based on a will and testament. Um, that's actually duplicative. I understand testament derives from a French word that means will, so it's really will and will. But the bottom line is the will names beneficiaries and names an executor. And the judge, on hearing, will admit the will to probate by signing an order saying just that the will is admitted to probate and the named executor is appointed as the executor of the estate. There is a second form of this probate process, Where there is no will, this is called intestacy or an intestate estate. And again, both testate and intestate derive from the last will and testament. Intestacy is creates a inheritance rather than a beneficiary. So you have heirs, not beneficiaries. And it's based on state law of descent and distribution. That just means who does the property descend to and who is it distributed to after the person dies who didn't have a will. The key nomenclature is a will names beneficiaries. The state of Texas law of descent and distribution creates heirs. It's the same thing, just different terms. It's who gets the property. All right, how does a testate probate begin? Well, it's initiated by filing the will along with the death certificate and an application to the court saying, please accept this will and admit it to probate and appoint the executor named therein. After the filing, there are other papers that are filed with the court, and then a hearing is set. There is a time period that has to pass before the hearing can happen. In Texas, the law is the notice and application have to be on file and posted for 10 days plus the following Monday before you can have a hearing. Traditionally, the probate courts will post the notice on a Thursday. 10 days after that will be the following week, Sunday, and the Monday will be the day after it. So by law, you could probably have a hearing as close as within 2 weeks. Now, in practice, depending on the size of the county, there may be quite a few probates ahead of you, and the court has limited time, which it breaks up into periods called dockets. And as those dockets are filled, it pushes you further and further into the future. So I have told people in Travis and Williamson County to assume that if you get your application in and filed, it's probably 4 weeks to a month before the hearing will happen. That's just both the application of the law and practical reality. Once the hearing happens, um, the court admits the will to probate by an order that is prepared and filed by the attorney. And I guess this is worth mentioning. In all the counties where I practice, the judges require an attorney to facilitate this. I don't know exactly the reason why. My guess is that they are working on the public dime, and their time is, and what I'm talking about here is the courts, the judges, their time is valuable. And if you have an attorney who's familiar with the process, they can keep it focused. And those who are not familiar with the process may tend to wander all over the place and essentially waste the court's time. So, just by fiat, the courts are requiring that all probates be initiated and facilitated by an attorney representing the applicant, the person in charge of the application, who is usually the person named in the will to serve as the executor. The hearing is a fairly brief affair. It's actually been made briefer in the last year because of the pandemic. Most courts have been having these hearings remotely, done by Zoom or Google Meets. And in both cases, to keep the time down, the hearing is usually a recitation where the attorney reads through the application one point after another, saying, is it true that your name is such and you live at this address? And then the applicant says, yes. Is it true that the decedent died on such and such date, at this age, at this location? And the applicant says, yes. And they go through the entire application that way, at the end of which time the court has heard enough evidence and do understand that what the applicant says in the hearing is the evidence. What the attorney says and what the attorney prepares in the application is just framing the issue. It's not evidence for the judge to rely on. But once the court has heard the applicant say these things or agree to them, that's sufficient evidence for the judge to sign the proposed order admitting the will to probate and appointing the executor. Just as a reminder, it's the court order that gives effect to the will. So that's what transfers title to the property named in the will to the named beneficiaries, and that's what appoints the executor. What does the executor do after being appointed? Broadly, it falls under three categories. To marshal all the estate assets, that means gather up all of the assets of the decedent. Decedent is the legal term for the person who's died. Then to determine and pay those creditors of the decedent that are valid. Um, Again, it's going through as any of us would do with someone who presented themselves as a creditor. Say, show me, prove that this is an actual debt owed by the decedent, and that the amount is correct, and then quite often negotiating to reduce that amount. But after those creditors are paid, and understand creditors are paid first, then the executor takes what is left and distributes it according to the will. So a couple things out of that are worth noticing. The first is creditors are paid first. There are 8 levels of creditors defined in the Texas Estates Code. It ranges from the costs of final burial or final illness and burial or cremation on down through credit cards, unsecured credit. Those are all paid to the extent they are valid, to the extent the amount is proven to the executor's satisfaction before anything goes to the beneficiaries. What other duties does the executor have? Well, after, and I guess the first is what I just said in the slide beforehand, are the actions that all executors must take. There are, in addition, 3 statutory duties set out by law that an executor must comply with. The first is to notify any potential creditors and the community at large that the decedent has died and that the decedent's will has been admitted to probate and that the executor has been named and appointed by the court. Secondly, the executor must notify the beneficiaries named in the will. And third, and perhaps the most time exhaustive, is preparing and filing an inventory of the estate. Now, to make this clear, it's only the assets of the estate that are listed. So liabilities and debts are not listed. And it's only, as we mentioned, probate assets, which are assets held in the name of the decedent. Let's go next to intestate probate. As you recall, this is the other side of probate where someone doesn't have a will. Once again, it's initiated by filing an application to probate the estate along with a death certificate. No will is filed because there isn't one. The first step the court takes upon opening this case is to appoint an attorney to represent unknown heirs or minor beneficiaries. It's assumed by the judge that there will be people who may not know about this proceeding, and they want to make sure they are informed about it. So the attorney ad litem's job is to inform them and to make sure that their rights and their potential inheritances are protected. Then a citation is published to the community. This is basically a notice that runs in the local newspaper, and it says the decedent's estate is in the process of being probated in front of the probate court, and anyone with an interest in the estate or related to the decedent needs to be advised of this so they can take appropriate steps to protect themselves. This is a considerably longer process than a testate or a will-based probate, primarily because there's a number of notices. For example, there's the citation to the community at large, and one needs to be published electronically through a state bar supervised portal. And there's at least 2 attorneys involved, the attorney representing the applicant to probate the estate and the attorney ad litem that was appointed by the court. There are higher filing fees. Just the filing fee to get the court involved is at least twice as high, sometimes close to 3 times as much as a probate of a will, because part of the filing fee is an initial 2 to 3 hours of time for the attorney ad litem. It's part of the filing. The attorney handling the application has considerably more duties to take care of. And so that attorney's fees will doubtless be higher as well. I guess one other thing, let me go back one slide. The intestate process, as given in contrast to the testate process, is lengthier and it's more costly. There is a form of testate administration that is lengthier than the traditional one, and that's called a dependent administration. Remember, the probate covers not only admitting the will to probate and appointing the executor, but also supervising the administration of the estate. And we went through the three statutory duties of an attorney and an applicant, or rather an executor appointed in the hearing to gather up the assets, to pay the creditors and distribute what remains to beneficiaries, as well as to notify both creditors, community at large, and beneficiaries, and to prepare an inventory. In a traditional estate, traditional probate of a will-based estate, what is generally recommended by the attorney supervising, or at least assisting the applicant, is to say, let's make this independent of the court's oversight. In other words, we will apply to get you appointed as executor a specific kind called an independent executor, which means after that initial hearing, where they recite the evidence and give the judge sufficient justification to sign the order, there's no more court hearings. That's an independent administration. It's what's generally conceived of as a very straightforward and short form probate. Sometimes, for a variety of reasons we're not going to go into, it's made a dependent administration. In this case, every action the executor takes, with a very few exceptions, has to be presented to the court for approval before the executor can take those actions. So, gathering up assets, um, notifying beneficiaries, dealing with creditors, every step of the way, the executor has to go back into court and get judge's approval for that, which has its own attendant fees for the attorneys involved and for the court costs. So a dependent administration does sometimes need to be done. Quite often it's used where the estate is underwater and there's more debts than there are assets. But an independent administration where there's no court oversight is usually preferable. What are the alternatives to probate? Well, I've listed four here. At the top, there's trusts. And think of trusts in this context, because it's too detailed a topic to go into here, as a contract that says the person who died owned the property and held it for himself as trustee and named a successor trustee at death that takes over. It's a private contract. There is no court oversight. There's no judges involved. It's simply a contract that says, I'm turning over the reins to these people when I die. And also, in case I become incapacitated, I have named a successor then as well. Another alternative to probate is making use of a beneficiary designation. This is used quite commonly in life insurance and retirement plans. And I'm assuming also this is more Bill and Tara's area in annuities, but you designate someone to take over when you die, and they simply take over because of that contract. You can also set up an account with survivorship provisions. The most common of these is where you have, for example, a husband and wife that own an account as joint tenants with rights of survivorship. It basically means whoever lives longer gets it. That acts by operation of law. It's another contract, and all these things take it outside of probate. And then the fourth is pay on death, POD, or transfer on death, TOD, where it simply says you have an account, perhaps at a bank, and at death, it pays to a named beneficiary. All these are alternatives. They are ways of saying, at my death, the property held in one of these contracts passes directly to the person or persons named in the contract instead of having to be governed by my will. So this is kind of an overview of, or a flowchart, at least how I see it, about traditional estate planning and how your property passes at death to the people who should get it. On the left side are the non-probate transfers, like I mentioned, for example, a jointly owned property between spouses, or a life insurance, or an IRA, or a 401k, or an annuity that named a beneficiary. Or in addition, you could put in their bank accounts with a POD or investment accounts with a TOD. And on the right side is property that's held in your own name. That must be probated. The probate is the process to take it out of your name and put it in the name of the people who should receive it. And your will is the guidebook for that. Oh, I did something wrong here. Okay. This is just an excerpt of a rather famous will. When Jackie Onassis died, she died in New York. Her attorney is actually a very well celebrated and very gifted attorney in New York named Jonathan Blotmacher, um, who still practices to this day. But for reasons made, I guess, clear to Miss Onassis before her death and then to her family thereafter, she used a will, not a trust. And there may well have been some tax concerns. I don't really understand that. But the bottom line is a will is a public record. So if you want to see who gets the property that someone else had at the time of their death, you can get it from the probate court. And it is possible to see, to this day, Jackie Onassis's will. It was kind of an open question at the time of her death. I mean, she'd been the wife of a president and later on the wife of a billionaire, and no one really knew how much she had. As I recall, it turned out to be about 20 million or so. So not chicken feed, but it was nowhere near as large as it was. And it answered basically prurient interest of those people who were, had any interest in finding out how much she had. Had she not used a will, we would not know what she had. And it's not so much the amount as the contents of the estate. It's clear from the will who benefited, who received this money. And although in her case she had a fairly high profile and it was pretty obvious who her beneficiaries would be, in many cases, this is a more private matter. And passing property to someone else um, can expose them to potential predators out there, not just the creditors, but those who are looking over to see who the new widows and orphans are and how much money there is to be taken from them. So understand that is one of the concerns with having it um, taken care of through a probate process. And this is not by any means meant to suggest you shouldn't use a will. They are a remarkably efficient and useful means of transferring property and making sure it gets to people, the right people, in the right way. And I guess the last part of this I want to say before going on to the questions is with all the privacy concerns and the costs and the probate proceedings, why would you use a will? Because a will allows you to explain how the beneficiaries should receive their property. In other words, suppose you're leaving property to a child. If you leave them property and they're underage, they legally can't accept it. So it's held in the guardianship of their estate by the court. And essentially, it's basically just held in a savings account and then it's given to them when they turn 18. I was once an 18-year-old boy. I don't think giving an 18-year-old boy or girl is really a great planning device. In a will, you can temper that. You can say it's given to them over a period of time or subject to a trusted friend or relative's guidance, or it could be given to them in a trust created inside your will. So the options inside a will are usually sufficient to make sure it's the uh, vehicle of choice for transferring title. I think that may be the last of my slides.
Hmm.
Oh, I guess there's a quote there, John Ruskin quote, and it basically summarizes and says, in probate and estate planning, as with anything else, you have a choice. You can pay too much, too little, or just right. If you pay too much, you do lose a little money, but that's it. When you pay too little, you stand to lose a lot more. because what you paid for, you didn't pay enough for, you didn't get a functional service or functional product. And the law of business balance prohibits paying too little and getting a lot. It can't be done. So, dealing with a lowest bidder, you might want to store away a little to cover the risks you run. And if you're able to do that, you might as well pay for the better thing in the first place. That's all I have for right now. And I guess we'll go to questions now.
Well, Andy, if you're going to summarize this whole probate process, bring it down to 2 or 3 takeaways, uh, what would you leave with our audience?
Okay. Um, the takeaway from today's presentation: probating a will is a legal process in court. It is conducted publicly, and there are costs associated with it. And the balance is that you are getting your actual wishes put in place as a matter of law, as opposed to just giving property to someone without any thought to how they receive it or what kind of additional gifts or protections you can give them.
That's great.
Okay, and just to let everyone know, Andy introduced the concept of using a trust as a way to avoid this public probate process. And we're going to be inviting Andy back in several weeks to talk specifically on different types of trusts and how they might be an alternative to the entire probate process. So, Andy, want to thank you for that today. Tara, do we have any questions?
We do. Let's see the list. And don't forget to go ahead and use that talk bubble on the top of your page, and you can type in your questions and we will get to them. So let's see. First question. If I have no will, do I go through probate?
Yes, you do. And that was, we talked about that a little earlier, but basically that's what's called intestate administration, where your estate is probated in front of the court, but there's no will to guide it. So again, it takes a little while longer, and there are other attorneys involved, the attorney ad litem, and it's a more costly process.
Okay. And I think you covered this, but how long does probate last?
Actually, I think what I covered was how long it takes to get it going. How long it lasts is dependent on how complicated your estate is and how difficult your will is to follow. The role of the executor in a will is simply the same in each case: to gather up all the assets, pay the creditors, and distribute, as well as notifying all the beneficiaries and the community and filing an inventory. How long that takes is determined by how difficult it is to locate all the assets, to gather them up, how difficult it is to deal with the creditors, and how difficult it is to find and distribute what remains to the beneficiaries.
Is there an end date? Like, do you have up to 3 years to get it done, or is there a timeline that you're supposed to get it done?
There is a timeline in terms of how soon you can bring a will, or how late you can bring a will in to be probated, and that's 4 years under state law. If you use it after that, it serves as what's called a muniment of title, which is kind of like a deed that transfers title to the beneficiaries, but it does not allow you to appoint a personal representative, either an executor or administrator.
Okay, good question. All right. How much does probate cost?
It varies. You can have a very simple probate, and you can have a very complicated one. Most attorneys are going to be charging by the hour. They don't know until they started working with you anything about you or the estate. So they can't say it'll cost X because they may be wildly inaccurate on that. Instead, they'll say, my hourly rate is such and such. I will need a retainer of a certain number of hours to get underway. And then at the end of the process, we'll settle up with how much remaining is due to me. There's also the court costs and the ancillaries. The court costs are what you're paying the judge to hear this probate. In Travis County, for example, it's $336.70 for the filing. And then there are subsequent costs, usually electronic, for filing the various documents with the court, like the proposed order and the oath of the executor, et cetera, and the inventory. And there's also a cost for filing the notice in the newspaper that you've been appointed as the executor. So I will tell people that it's probably going to range on a vanilla probate where there's not a lot of people contesting it, no real court hearings beyond the basic one, between 2 and 3 thousand, and it could be less, and it could quite possibly be more.
Okay. Good. So do you probate your stuff like furniture, jewelry?
Very good question. Technically, no. Probating is transferring title, and you don't usually have, most people don't have furniture or jewelry that has a title to it. In that situation, that stuff uh, falls under the old legal saw possession is 9/10 of the law. If you have that property, it's pretty much yours.
So then the will is what's going to tell you I give my oldest the furniture upstairs or the
Right.
clocks or the whatever. That's where the will comes in to distribute things that don't have titles
Yeah,
in
the
them.
will have sort of a generic reference to that. The stuff I have, the personal property, um, will pass to, say, oh, like you said, maybe all my kids, and they can choose round robin what they want, and then do what they will with the rest.
Okay. That makes sense. Okay. Um, is naming a beneficiary to a bank account the same as a POD designation?
Very similar to it. A beneficiary designation is usually used not so much in bank accounts, but in contracts with companies like insurance companies for a life insurance policy, or um, those companies that administer retirement plans. You designate a beneficiary. A POD has the same effect. You are naming someone to take the property, and it's paid on your death.
That makes sense. Okay. What happens if all else failed and the executor was not able to deal with a probate in excess of 4 years and cannot really afford to hire an attorney? Pretty much everything is gone except for the bank account, but she's left no beneficiary on this account, and the bank isn't very helpful or maybe isn't allowed to comment in spite of the fact that the executor shared the joint account with the decedent.
Hmm. Um, this does sound like a more detailed question that I can answer in a survey, because there's some facts that will have to be ascertained. Primarily, this is a matter of negotiation with the bank. Sometimes they will end up, it doesn't sound like this is the case. Occasionally, they will be reasonable and say, here's a private, informal route that we will accept. Like we have an in house form with an affidavit of heirship. And if you get everyone to sign off on it and we think we're covered, we'll turn the account over. Um, I'm curious, you said it's a joint account. Joint account is usually co-owned by the joint tenant, which means that tenant would still have access to the account and could simply take the money out. If it's in fact the term you're using, joint account, is referring to signatory authority, that's similar to a power of attorney, and it stops at death. So there's some things in the question that are a little uncertain.
Okay. Let me see. So she's commenting back.
Oh,
No, it was another account. There was a previously a joint account in addition to that account.
okay, so this is an account that didn't have a beneficiary, didn't have a joint owner, and the bank is being difficult to deal with. Honestly, this is more than the subject of a survey. I think this may be something where it's possible to sit down with a probate attorney. It sounds like in Bear County, and say, what are my options, and get a specific answer to this. I'm sorry to be vague, but this is there's a lot of different possibilities.
Okay. Let me see. Oh, yes. And Christina, I will send out the slide deck and the presentation recording so that someone was asking about, oh, can we see the diagram again? And I'll be sure to post that again. Okay. What about a transfer on death deed?
That's very good. That's a very, well, in law terms, a very recent innovation. Um, it had been noted that there's TOD or POD, pay on death, transfer on death for bank accounts. Why shouldn't there be one on land? And the legislature finally passed a law called the transfer on death deed, or actually revocable transfer on death deed, a law in the last 4 or 5 years. Um, it tends to work pretty well. It does avoid probate. It does avoid, and this is important, Medicaid creditors. What it doesn't do is avoid other probate creditors. And the concern that my clients and others have reported on this is, if you use a transfer on death deed and the property passes to the beneficiary, because it's still subject to probate creditors for another 2 years, title companies will almost never insure the title for any time earlier than 2 years after the date of death.
Hmm. Okay. What if the executor has passed who serves as executor?
Well, that's actually a good case in point on structuring your will. You should always, in any kind of legal document where you're appointing someone, name alternatives. Um, if you name someone, sometimes husband and wife name each other, and then one of them dies first, the other one doesn't have someone named. You can get all of the beneficiaries in the will, if they can agree, to ask the court to appoint a new administrator. And it can be set up independently. But do understand that's an additional cost and time passage to get that taken care of.
Okay. Um, yes, and someone asked, can I send a soft copy of the presentation? Of course, I will. I will send the slide deck as well as the recorded presentation since people were interested in it. All right. Well, I think that's all the questions we have for today. So we really appreciate your time. Please don't forget that next week we're going to have number 10 in the series. And what's the title of that one?
We're going to be talking about the true story about modern annuities. We call it the good, the bad, and the ugly. And it's talking about features that are recognized as being very good, and then also what critics say about these products, how they've evolved over time. So, if you're interested in a safe, secure retirement, and if guaranteed income during that retirement is important to you, which in our practice we believe guaranteed income in retirement is very important. We use a variety of products to help our clients create income, just like when you're working, so that paychecks keep coming and you don't worry about how to pay your bills. But so tune in next week, 10 o'clock on Tuesday, for the good, the bad, and the ugly, the story of modern annuities.
Okay. And also, I'll be sending out the link to that so you can go ahead and register for it in advance. As well as a free copy of our book, More Money for Retirement, the second edition. It'll be a PDF form. You're welcome to read it online. And I guess that wraps it up for us. Thank you so much, Andy, for speaking on probate today. And if you have any questions, feel free to contact either Bill, myself, or Andy at these phone numbers and email addresses on the screen. All right. Well, we look forward to seeing you next week and have a wonderful week.